subject of this masterclass is going to be the combined appeals that were heard by the Supreme Court earlier this year in the cases of Rubin and Eurofinance SA and NewCap Reinsurance and Grant. Both the cases concern the enforcement of insolvency judgments obtained in foreign jurisdictions, their enforcement in this jurisdiction. And the Supreme Court decision was hotly awaited because it was thought that it was going to introduce a brave new world of cross-border enforcement of insolvency judgments. Regrettably, it didn't do that, but both cases are very interesting and worthy of consideration just the same. My name's Lexa Hilliard. I'm a member of Chambers at 11 Stone Buildings. I'm a silk, and my areas of practice are insolvency, company law, professional negligence and general commercial litigation. Before I come on to discuss the two insolvency judgments that I just mentioned in the Supreme Court, I think it will be useful if I just give a brief overview of the rules that apply as a matter of English law in relation to the enforcement of foreign judgments in this jurisdiction. So under English law, a foreign judgment will be enforced if, as a matter of English law, the foreign court had jurisdiction over the defendant when the judgment was obtained. And as a matter of English law, a foreign court will be treated as having had jurisdiction over a defendant against whom a judgment is entered. Firstly, if the defendant was resident in the jurisdiction at the time the proceedings were commenced. Secondly, if the defendant actively defended the proceedings, put in a defence and actively defended it. Thirdly, if the defendant put in a counterclaim to the claim against him. I mean, that's another way of saying that they actively participated in the proceedings. And fourthly, if the defendant actually, prior to the proceedings, entered into some form of agreement as part of the contract that the defendant entered into on which he was sued, effectively agreeing to submit to the foreign jurisdiction if proceedings were commenced. Now that is dealing with the jurisdiction of a foreign court in relation to judgments in personam, judgments personally against the defendant. When we're dealing with judgments in rem, i.e. judgments concerning movable or immovable assets that have been given handed down in a foreign jurisdiction, then as a matter of English law, the foreign court will be treated as having jurisdiction for the purposes of a judgment in rem if the movable or immovable property was situated in the foreign jurisdiction at the time the judgment was obtained. So that's a brief view of the position outside the insolvency context.